Hello and welcome back to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group. We have offices in Ridgewood, New Jersey, and we also have an office in Midtown Manhattan, and we have offices, affiliated offices in Mumbai, India, and also in Canada. So today I want to talk to you about a provision of a law called American Competitiveness in the 21st Century Act, AC 21, Section 105. In a prior video, we talked about Section 106C, which deals with the immigrant visa classification, and that has to do with what's called mobility, where an individual gets a property right in the green card process when it's done by the employer. Today I want to talk to you about a different provision, which it's really good for you to know about if you're an H-1B non-immigrant. And this provision is called Section 105. Section 105 allows for what's called portability, H-1B portability. So what is H-1B portability? Well, it's pretty easy. The concept is this, is that if you're an H-1B non-immigrant in the United States and you receive an offer of employment from a new employer, what you're able to do is you're able to file the new H-1B, and upon the proper filing of that new H-1B, you can port or move to the new employer without waiting for the H-1B to be approved. And that's a really nice mechanism. The reason why is because a lot of times employers need an individual's skill set very fast, and so what portability does is it gives them the ability to get that person quickly onto the payroll. Now, both the employer and the employee, though, have to be careful about portability. And the reason why is this. If an employer says to an employee, hey, listen, come on over to our company, we'll use portability and we'll file the case. Well, that's fine. The individual then comes over, let's say the H-1B is filed, and that it's fine if the H-1B case gets approved. But what happens if that H-1B case doesn't get approved? So, as everyone probably is aware, 245C says that you can't be working in unauthorized status in order to pursue the green card. And what happens if the individual ports over to the new employer and then that case ends up not necessarily getting approved, but it ends up getting denied? Obviously, if the individual is ported from company A to company B, they may have actually burned their bridge with company A and they may not be able to get back there. And so then the question becomes, are they working out of status for company B? And if so, then does that ultimately affect their green card? So H-1B portability is not something that's not something that should be taken lightly. It's a very complex issue, and the issues of portability, both for the employer and the employee, should be thrashed out before it's decided that portability is used. In fact, in many cases, rather than using portability, what some companies will do is they'll encourage the H-1B non-immigrant to use what's called premium processing. Obviously, premium processing, if you pay an additional $1,225, you'll be able to get a decision in 2 weeks, and that might be enough if you can get that decision quickly. Okay, and so, and I'm assuming that everyone who's watching this video knows that if you already have an H-1B and you're going to a new H-1B employer, that is a cap-exempt case. You don't have to worry about waiting until April 1st to file that case because it's again, cap-exempt. So, what do you need to be able to show in order to take advantage of Section 105 portability? Well, the first thing is that the petition that's being filed, the H-1B petition, where the individual is moving from company A to company B, has to be non-frivolous. So what that means is that it has to be a real H-1B petition. The beneficiary has to be a non-immigrant admitted to the United States. There is no particular non-immigrant status that the individual who's porting has to be in. So for example, let's say you have an individual who was H-1B, but let's say later on, maybe they were, maybe for example they were laid off and they changed their status to visitor, B2, and then they're looking to go back from B2 to H-1B. Can they use the portability provision? Absolutely. They also have to have been issued an H-1B, which I just said, so the individual has to have had an H-1B in the past. They cannot had been employed without authorization before the petition was filed. So no unauthorized employment. If there was any unauthorized employment, unfortunately you cannot use the portability provision. But of course the fallback then is to use premium processing, and then if there is any type of gap time, you would want to do that on what's called a nunc pro tunc basis when you file that new H-1B. And in a later video we'll tell you about nunc pro tunc and how that process works. Also, the individual has to be in an unexpired period of stay when that new petition, that second H-1B petition, is filed. So those are the criteria that you need to meet in order to take advantage of H-1B portability. But essentially what happened was, under AC-21, the government was very concerned about H-1B non-immigrants who were sort of locked into the positions that they had with their first employers, and they were unable to move quickly to other employers who needed their skill sets. And what that did is essentially it put a damper on free market movement of H-1B employees. So now with the implementation of portability, it allows for the flow of these skill sets between various organizations. So I hope that information is helpful to you. Once again, it's called Section 105 of the American Competitiveness, the AC-21, the American Competitiveness in the 21st Century Act. If you or your staff or any of your friends have any questions at all about AC-21 or the use of the portability provision under Section 105, please feel free to call any of the lawyers here at the NPZ Law Group. We'll be more than happy to help you. Stay tuned for some additional information about various immigration issues. Thanks so much. Bye now.